Okay. Spousal impoverishment. So spousal cases get a little more involved because it's not as cut and dry with the asset limits. Just single, widowed, divorced, never married individuals, it's $2,500. When you have a married applicant, we determine eligibility based off of the assets the first of the month that they apply and the first of the month that they're in the nursing home. So we have to look at assets on two different dates to determine if they're within those resource limits. So we have a minimum limit. Anything below that minimum, if they're under the $23,844, it would be safe to say that they would qualify for this form of medical assistance. It's anything above and beyond that minimum asset limit for spouses where it's all dependent upon what their assets are at the time that they apply and the time that they went into the nursing home. So we use a worksheet to determine that, and then the computer also calculates that automatically when we're processing eligibility. There's different sections, and it's half of the assets during the month of institutionalization, or the maximum share, which is now $120,900. And we take whatever's least, and the total assets of the month of the application. We subtract the first amount from the second amount, or that minimum spousal share of $23,844, whichever is greater. And this is the amount of the resources that are attributed to the applicant. Eligibility is determined if the number is below 2,500, then the applicant would be eligible. If the number is above 2,500, then the applicant would be ineligible. It's impossible to give an eligibility determination without both of those dates, though. Did you want to add anything? Yeah, and the person has to be in a nursing home for us to determine eligibility for married applicants. Are there any questions? Okay.
So this is for somebody applying for long-term care to go into a nursing home, long-term care, correct?
Correct.
So what if their assets are above this? Does that mean they have to spend down first before they can be eligible? Does that mean they can go into a long-term facility and pay privately until they spend down, or what does that mean exactly?
Correct. And that's because it's impossible for us to know what the assets are. If they're not already in a nursing home, we don't have a specific capture date to calculate the difference between the 2 months that we're using to determine the assets of the time they went in and then when they're applying. So unless they're going into the nursing home the same month that they're applying, the balances are for any assets that they have are going to be different.
But can they also apply before they get into the nursing home?
The question is, can you apply?
Like if family members.
Yes,
So
you.
like if a family member is feeling they can no longer care for their loved one and they're looking for long-term care placement for them, they would be applying for this, that they're not already in the nursing home. And let's say they're above, their money is more than what they'd be approved for, so would they then shop for a facility that would be private pay, then apply again?
Okay, the question was, can you apply before you go into the nursing home? And the answer, of course, is yes. The period of consideration that will leave an application pending is 6 months. So if they go into the nursing home anytime within those 6 months, that would allow us to make that determination. They always also have the option to pay privately.
Ask her if she's speaking of. Are you speaking of a spousal or individual? Your question that you was.
Okay. Yeah, an individual application is completely different. An individual, you can apply anytime, and if we know that you're above $2,500, we can determine that you're over the limit because that number is a fixed number and it has not changed.
So then you would go into a nursing home and spend down before reapplying?
The question was, would they have to go into a nursing home to spend down and then reapply? Yes, That is correct, you can do that. It also, with our denial, allow you to find out how much over the limit that they are financially, and this is for single adults. And we would be able to kind of instruct you on how to appropriately spend down your money, so we won't have to worry about things like transfers and gifting away money. Mhm. Any other questions about this? Okay. This is an example of how we calculate the spousal allowance eligibility, or not spousal allowance, the spousal impoverishment eligibility. So if Bob entered the facility on January 16th, 2017, and he is married to Sally, the total resources for Bob and Sally on January 1st were $186,000. If Sally submitted an application for long-term care medical assistance on Bob's behalf on May the 1st, they had previously been paying privately for nursing home care, and their assets of May the 1st are now $97,000. Okay, so we would look at half of that first month of institutionalization, which would be January the 1st, 2017, which of $186,000 is $93,000. Okay, and that would be the answer. All the others would be incorrect. So being that they're, oh, I thought you gave it all, sorry. Okay, so step B would be taking the $97,000 that they had on May the 1st and then attributing $4,000 to the applicant. And Bob would not be eligible since the $4,000 attributed to the applicant is greater than C, which is the $2,500. Any questions on that?
Where does May 1st come from?
May 1st is the month that they're applying.
Oh, okay.
January 1st is the month they went into the facility. So we're comparing the assets from those two dates.
So how would it only be four?
4,000 is the difference between 97,000 and 93,000. So half of that 186,000 that they had the first month Bob went into the nursing home, we would only say that they would be eligible to keep half of it. So as of May 1st, they still have $4,000 more than what the eligibility preservation amount would be. And so that $4,000 being over $2,500 is what makes them ineligible.
And so the actual 97,000 is what she can keep.
The 97,000 is what their assets were. The 93,000 is what would have made them eligible. They could only keep half of that $186 or $1,000. Sorry. Okay. Any other questions about? Yes, ma'am.
Whether it's a spousal situation or an individual situation, what if the assets aren't liquid?
Okay.
So there's $4,000 left that makes that person not eligible, and then they don't have.
What type of asset would you be?
So a single person or an individual, maybe someone who's widowed or something, they have a home
Mhm.
and maybe they have a mortgage on it.
Well, the home is something completely separate, and that was talked about earlier, where if you are in a nursing home and you own your home, as long as you have the intent to go home, we have the possibility of putting a lien on it rather than looking at it as an asset. In the event,
What if they're not going?
okay, if they're not going home, then we would look at the equity value. So if they still have a mortgage, it's whatever the fair market value of that home is subtracted by what they owe on the mortgage
So
to
say-
determine the equity value.
Say the equity's $25,000, but they don't have $25,000. How does that work you know what I'm saying?
It's still, we look at for single adults, it's $2,500. So if they mark that they have no intent to return home, then we look at the equity value, and it's anything above and beyond $2,500 is over the resource limit.
So what does so say someone went into a nursing home, and when they're in the nursing home, they have to apply for long-term care because they're not going home.
Mhm.
And then they get in that situation where the situation you just described, so then they're not eligible, but they can't return home.
Well,
the
it's
house
not,
might be sold
it's
or
not
whatnot.
necessarily can't return home, it's intent to return home. So it doesn't need to be a reasonable expectation that these individuals would be going home. It's, the way I like to think about it is, if they were able to walk out of the nursing home the same day, is that where they would be going back to? And if the answer to that is yes, then we would exclude it as a resource and go the route of a possible lien on the property. Okay. Yes, ma'am.
So back to this example, if on May 1st, their assets were $94,000, then Bob would be eligible because they would be below the
Correct.
2,500.
Yes.
Okay.
The question was, if the assets were lower than the 93,000, if it was 94, we would, so there would be less than a $2,500 difference, and Bob would have been found eligible for medical assistance. Okay. Any other questions on this slide? All right. The spouse's income is not factored in until the post-eligibility period. So we wouldn't look at it until after the client was deemed eligible for long-term care medical assistance. The only time we would ask for verifications is if they were trying to see if they could receive a portion of the spouse who's in the nursing home, their income, to help supplement the community spouse's income on a monthly basis. So if a spousal allowance deduction is being requested, then we look at their income along with their shelter expenses to see if the applicant qualifies to have what they owe to the nursing home be reduced to, for the spouse to keep more of the institutionalized spouse. Lost my words there. Okay. Give a portion of their money instead of giving all their income to the nursing home. Okay. Shelter expenses that we look at are mortgage, rent, ground rent, utilities such as heating, cooling, water, phone, property taxes, homeowners insurance, renter's insurance, and I think that's pretty the standard.
Condo fees.
Yes, ma'am. Condo fees, HOA fees.
Car insurance.
No, we don't look at any car insurance.
No cable.
Yeah, cable's not one of those either.
But phone is.
Phone, yes.
$40.
Okay.
Yeah, there's standard deductions. If they're paying for heating and cooling separate from their mortgage or rent, they normally qualify for a standard deduction, which is like the maximum that we can grant. And that changes on an annual basis. Right now, it's a $416 deduction equivalent. Any questions? Okay. Okay, yes, ma'am?
I have a question. On the example, this is strictly an example, spousal allowance example.
This right here?
Yes.
Okay.
So it's 1,218. That varies?
Yes, because it's all dependent upon the, let me see, it's all dependent upon the spouse's income relative to their shelter expenses. So we would look at income, all income across the board, Social Security, employment, unemployment, pensions, retirements, civil service annuities, anything like that, minus the shelter expenses. And then there's different standards like the excess shelter standard, B, C, or D, the basic maintenance and shelter, and the maximum maintenance and shelter. Those standards actually change, and they're found on a Schedule MA8 that you can find online, but they're updated, I think, annually as well. Okay. All right, trusts. Anytime there's a trust, we have to send that downtown to a specialized unit. So all we do on this is collect the information and we forward it downtown. They're the ones that review it and make the decisions on whether or not any trust would be considered a countable asset. Okay. assignment of support rights. Because Maryland is a spouse for spouse state, we are supposed to calculate the assets for spouse, his, hers, and theirs. So in the event that a spouse out in the community is uncooperative and is refusing to provide some of the following, we can do what is called an assignment of support rights along with a notary certificate, such as when the spouse's whereabouts are unknown, they refuse to provide their financial information, or they actually refuse to pay for the applicant's medical nursing home care. And so what this does is if any of those three instances occur and we get that form filled out, it allows us to bring criminal action for non-support against the applicant's spouse. Yes.
So this would be if a person's separated but still legally married.
Correct.
They haven't, had their spouse in their life for the last 20 years and they don't even know where they are. Even if they're out of state, it's still.
Yes, the question was, does this pertain to individuals who are married but have been separated and estranged, or the spouse is living in another state? Yes, that is correct. It allows us to treat the applicants that are married as individual applicants, where we would go back to just looking at the $2,500 a month resource limit. Any other questions with this? Back to you, Angela.